Okay, Shannon, you could put us on.
Okay.
Peterson versus Wise Choice. Mr. Marienfeld, this is your motion to compel.
Yes, Your Honor. And I'll just be real brief. We served interrogatories back in August. They were due in September. We're a little bit overdue. This is not a reflection on Mr. Donahoe. I think he's in a pickle, to be honest. So I don't fault him at all. But I think we need to get some type of an order and set a deadline here, because from what I understand, there was a claim that the defendant owner is in Pakistan. It may or may not be true, to be honest. At least that's what Mr. Donahoe is being told. I went yesterday over to this car lot where the vehicle burned down, which is the subject of this case. And there's new vehicles there that weren't there the last time I was there. So there's something going on over there. I mean, it's a flat, there's no building anymore. It's just a flat lot, but there's other vehicles in there. So I don't know if it's just people parking there or if he has some action going on over there, but I would just like to get an order that maybe 2, 3, 4 weeks, whatever you think is reasonable, to get answers to the interrogatories.
I think one thing is clear, whether or not the owner of the LLC is out of the country. The LLC isn't out of the country. It's still here.
Yeah.
And so I'm gonna order that complete answers be filed and served within 21 days from today's date. If they're not, then Mr. Marienfeld, you may want to move for some kind of sanctions. Again, Mr. Donahoe, I respect the fact that you can't produce things if you don't have a client that's cooperating, but your client will end up facing those consequences.
Yes, and I will do my best to try to get that information to him.
Okay, great.
All right.
Thank you, gentlemen. I'll watch.
Thanks, Ron. I'll
for
prepare
that
the order.
Have a good day, gentlemen.
Thank you.
Thank you, Ron.
See you, Tony.
Bye-bye.
So Julie, I don't see Corey McCord appearing yet, so I've been waiting for him before I call that case. I know he might be in another courtroom this morning.
Oh, okay. I didn't bring the laptop. I would email him, but I'm unaware of him having other plans. He didn't contact me saying he was.
Peter, why don't you see if you can get a hold of Mr. McCord and find out where he is? I don't want to keep everybody waiting if he's not planning on coming.
He may have forgotten.
His client's here. We'll give you a chance to do that. In the meantime, I'll just call something else. Tapping. Okay, let's get these folks in. I've got Mr. Lindsay, Mr. Bankston. We got the tappings. And we've got Kathy Slack. Okay, tapping versus Slack. I think I have everybody here. I don't see any other names out in the waiting room. Hey, Peter, if you could let him know Corey did log in. Okay, sorry about that. I just was trying to lasso my law clerk. Okay, so just to let everyone know, in case you didn't get the word, I did make it out to the property yesterday afternoon and had a chance to look things over very well. Anyway, so Mr. Bankston, I think this is your motion for a preliminary injunction?
Can you?
It is, Judge.
Oh, sure. So just so that if there's a need for a transcription, our transcriptionist knows who's here? Mr. Bankston for the plaintiffs, Mr. Lindsay for the defendants, Mr. and Mrs. Slack are present, and Mr. and Mrs. Tapping are present. Go ahead, Mr. Bankston.
Your Honor, Mr. and Mrs. Poulter are here as well.
Present with you?
They're the phone number that doesn't have a picture with it.
They're waiting in the room, she said.
No, they're not. That's Shannon.
Oh, do they need to be let in, maybe? Hold on.
That's
Looks
what
like
she
they
said.
do. Hold on a minute.
I'm sorry. They said they were here, and so
Well,
I didn't know where here was.
They are in the waiting room. Well, they may have. I've got a Jeff. Well, here we go. Carrie Poulter. Let me let her in.
That's it.
All right. As soon as we have an audio connection, we will proceed. Okay, looks like we're connected. So Shannon, also Mr. and Mrs. Poulter are present. Okay, I think we're ready to go forward with your arguments.
All right. Shall I get started, Judge?
Yes, please.
Okay. Your Honor, yes, this is our the Tapping's motion for preliminary injunction. At the last hearing in this matter, that was a motion for summary disposition. I had indicated that the season being what it is, it's getting on towards spring and summer, well into spring, even despite the snow, I suppose. And the Tappings are very much interested in being able to use their property effectively along the water this season. And I know we have a trial coming up on June 7th, but I think there are a couple things that the Tappings would like to see done now by way of relief. And I've outlined, and I know the court has read the motion, and I outlined, of course, the standard for relief in a motion in the motion for preliminary injunction. One of the things that is interesting to me is in a motion for preliminary injunction in a property case, you know, to take an analogy, if someone were to take a big load of dirt and dump it on someone else's land, they could say, oh, well, that's the status quo. Or they could say, you know, what's the irreparable harm of my leaving that big pile of dirt there until litigation is concluded? That doesn't seem to fit very well into property law where you have disputes between neighbors. But I point that out because in a motion for preliminary injunction, you're seeking immediate relief in a property dispute, primarily so you can use your property as you intended it to be used when you purchased it. And here we have, as the court knows, some obstructions down by the water line, as the court has, I think, visually observed, some obstructions down by the water line, which prevent my clients from accessing their property by the use of Pebble Drive. Even walking a dog across those obstructions is somewhat perilous. But either way, my client would like to be able to use, at a minimum, his ATV to get down there. But beyond that, what becomes of the ability to perhaps put sand in at the beach? I know the defendants have offered the idea of removing one section of railing. And, you know, it's just not, it's not sufficient under the circumstances. There's going to be maintenance that the plaintiffs need to do. Yes, the dock, and I want to, well, a couple things I want to clarify. One, it was my mistake to keep referring to the size of the limestone rocks as 3 by 5. It's a classic hashtag versus, it's a foot versus inch issue. And I do apologize for the court, to the court for that. The actual rocks, I believe, are, you know, 4x6 or something like that. They're not 3x5 inches, but they're close to that. So if I accidentally led the court on to think they were 3 foot by 5 foot rocks, that was my error that I kept propagating. But in any event, the ability to get sand in there, the ability to do maintenance. I think the last hearing that was mentioned that my client's dock was already in. So, you know, the fence didn't prevent that. Well, the dock was already stored down at the beach. So it wasn't something that had to be carted down. The dock was already down there. Now, what's not on the dock are bumpers, lights, etc. That my client would like to put on there. But beyond that, is just the ability to get, if necessary, a truck for sand delivery down there. It's just not an option with the obstructions as they currently stand. So, from a addressing the standards, irreparable harm. Well, I also want to mention, and I think the court may know this. My client injured his Achilles tendon. He has 2 children, I think age 4 and 6, who are going down to the water, and he has some difficulty getting down there presently to supervise them at the water line, which is obviously a pretty important thing to be able to do. These are factors and considerations that inform our motion for a preliminary injunction.
So, Mr. Benson,
yes.
let me stop you. One thing that was patently obvious to me when I went there is the potential for significant erosion to take place if there's a large rainstorm. Just the nature of that steep lane. And there were obvious signs of erosion and clearly some attempts to try to control the erosion. If that area that you're speaking of, the last 1 or 2 rail sections, is filled in sufficiently to allow a truck to go over it, what happens to the water in the meantime?
Sure. So Judge, if you're referring to the erosion of the berm, the hillside as you're going down on the left-hand side of Pebble Drive, there are some rock or check dams that are installed along there that are meant to slow the water down. But as our own surveyor has pointed out, water goes around rocks. So it goes to the right, it goes to the left, and it is cutting into the hillside as the court, I think, is accurately observing. But
it's cutting into Mr. Bankston, it's cutting into the road as well.
Sure.
Water goes where it will. And when there's a lot of water coming with a lot of force, it can do a lot of damage. I just, has any consideration been given to that? Obviously, I don't know what was there. I don't know what was there before.
Yeah, sure, Judge. We actually met all the parties, plus the surveyor, plus the township drain commissioner. We all met this last Tuesday out at the property to discuss drainage issues. And I think there's some ongoing discussions that are going to be moving forward to solve the drain issues as a separate matter from the access issue. So there's no question. Well, that drainage is on everyone's mind.
They're related, Mr. Bankston. They're related issues. If the measures that are in place now look like they're probably adequate to maintain, to reduce the potential for significant erosion, but the moment you try to fill in that area, when the water reaches that point, it's going to make its own ditch.
I understand, Judge, but the ditch, as it presently stands, does nothing to. There's already a plume of water that rolls right off into the lake. The ditch itself that was dug by the poulters right along that fence line, and we're talking right down at the water. Or close to the water, where my client would access the property. The fence, of course, obviously has nothing to do with drainage. The ditch and the rocks were meant to prevent access of an ATV or any vehicular vehicle over that land, not meant to control water. They were not put in for that purpose. I don't think there's any suggestion that I've heard that it does anything with respect to controlling, or handling the water. It's already coming down that hill as you observe at a pretty high velocity. That ditch filled with rocks doesn't do anything to stop that. So I guess from an obstruction point of view, I would just make the argument that the things that are there are intended to block access and were not primarily intended to control water, as opposed to perhaps the check dams further up the road.
Okay, Mr. Lindsay?
Your Honor, a couple of different things. First of all, I'm glad Your Honor had a chance to take a look at it, because I would actually be glad to put my clients under oath right now and have some testimony about why that ditch is there. The reason it came about was because Mr. Tapping was complaining because the water was basically ending at the bottom of that hill and flowing over his property. And so that ditch directs water directly along the edge of the Slack's property, so it doesn't go onto the Tapping's property into the lake. So I'm not an engineer, but I can stand and look at something and know where the water's going. Your Honor, I just want to. There's several different.
Let me stop you for a minute.
Yeah, absolutely.
There's no question in my mind that at least, and perhaps the primary purpose of the ditch is to control the flow of water, but certainly there's not much question in my mind that it was built without any consideration given to how the Tappings were going to be able to get onto their property over this lane. Certainly, it was built in a way that would keep that from happening. So, I mean, one possibility is a culvert could be put in, which would solve, at least temporarily, it'll give the water a place to go without creating any more erosion. Keep it flowing generally in the direction that it's flowing. I don't know if that a ditch at that area were just simply filled with those large rocks and smoothed out sufficiently so a vehicle could get over them as a temporary measure, that might solve the problem as well.
Your Honor, I think that's what we're suggesting to the court. Just a little bit of what Mr. Snyder came out with us on Tuesday, and I guess two things. First of all, in the documents submitted to the court, there seems to be there's an implication or maybe an outright statement that he opined about what happened on Pebble Drive, and he said as we were headed down from the south down the hill that he never looked at that at all and had no opinion that he provided to the court. So I just wanted the court to be aware of that. But as we walked down the hill, he explained to us how the drain code worked and what he would do if a drain was petitioned. And he said he would put something in that would be in excess of $200,000, and it would address the drain issues, and it would have a series of sumps as it dropped down. It would need to be maintained over years, because he's the drain commissioner, and that's how you would address that with a drain commissioner. I guess, Your Honor, and he actually said at the end of that, he suggested, why don't you'd have to put a culvert in here because it's just going to wash out. I guess, Your Honor, from our perspective on a short-term basis, just smoothing the rocks back out will allow the water to flow through the rocks. That's what we would suggest. And as plaintiff's attorney said, we have a trial in June, and we can address a long-term solution to this maybe. I actually had an email from Mr. Bernstein this morning about, talking about some other options that we may be able to address as well. I guess I would say what they've asked for in the motion is to grade that flat. And to me, that makes absolutely no sense, because as the court observed, the water is going to find a place. It's just going to erode again. My clients have worked very hard over the years to maintain that and to keep that water flowing the way it does flow. So that would be my suggestion to the court. And I guess the other thing I would just in relative to the merits of the motion, just part 3 deals with this harassment issue. And I just don't think there's sufficient facts in front of the court to decide that. My clients dispute every one of those issues. And then they also are requesting, he talked about the status quo, and it's interesting because he actually said, dump a big pile of dirt on your property. That's exactly what they did a year and a half ago when they expanded their property onto the Slacks property by basically bulldozing it out. So where you saw that ditch that's dug down, that's dug down to where the property was before the Tappings expanded their property onto that easement. So, I would of course argue the status quo is the way it's been since June of last year, or it's back in 2018 when this whole thing started. And I understand the court, that's your role to decide what the actual controversy is before the lawsuit started. And again, they're asking for the exact relief that they're asking, as an ultimate resolution to this. And again, the court's observed it. I mean, I think basically with an hour with my client's tractor, they can grade that so an ATV can access it, take out those center rails, and allow Mr. Tapping to be able to drive an ATV on that property, which should resolve the issues on a preliminary basis. I'd be glad to answer any questions.
Is there anything further, Mr. Bankston?
Yes. Oh, yes. If I might respond, let's take these issues one at a time. The fence. Let's talk about the fence. The fence, as it stands, if they remove one section of fence such that an ATV can get through, we're still not addressing the possibility of getting sand down to the property or doing work on the beach that would require any kind of maintenance beyond what an ATV could provide. So, I kind of object to the notion of this allow stuff coming from the defendants. We allow this, we allow that. I understand they make the claim it's their property. I don't think they have an adverse possession claim. I don't think they can show that. I've got discovery out there on that issue, and the court already knows how high that standard might be. But on top of that, they've got some deeds from, I think, was it the late 70s, early 80s, from purported heirs of okay, we'll go with. We don't know if they captured all the heirs. There's been no adjudication along those lines. I think there's a counter complaint to quiet title along those lines. I suppose we could put the defendants to their proofs on whether they actually have legal title. But in any event, this idea of allow from the point of view of the fact that there is an easement here for access. And of course, if there is in fact an easement, there's much more than an easement if I apply the existing case law that I've cited. Or rather, it's a special kind of easement that gives the Tappings extra access, which is to say no blocking of the property anywhere along that point of the road. So, I understand defendants making the argument. I'm trying to get all the relief that I've sought in my complaint here in my motion for preliminary injunction. That's not true. But I do think that, for enjoyment of the property as it was intended, I've got irreparable harm from my clients being unable to be down there with their kids. I've got harm from the inability to bring sand down there. So from a fence point of view, I think that more than a single railing of that fence has to come down, or a single section of that fence. So that's the fence. And that's a separate issue. Now, as far as rocks and ditch, okay, I mean, listen, if the idea here is that we can, somehow put in sufficiently smooth bed of rocks in that ditch such that both the ATV and a truck bringing sand in can traverse it, fine, then we'll have to live to fight another day on whether that ditch really should be there either, especially from an erosion point of view, erosion control point of view, because I think that would be an part of an ultimate solution on erosion anyway, whether that ditch needs to be there or not. And as the court suggests, maybe a culvert is a way to go. I don't know. But from an access point of view, it is interesting to note that ditch was dug right where that fence is. Those rocks were put there to block access, for the defendants to to suggest that it was simply there for water control. It just happens to block my plaintiff's access to the property. So that's kind of my response to that. And we'll just I'll leave it to the court's discretion.
Okay, so I think there is a strong likelihood of success that I am going to find that there is indeed an easement as described in this unrecorded plat that benefits the Tappings property. The full scope of that easement is going to have to wait for another day. I want, and the irreparable harm here is they're going to lose part of the summer season. I can't ever give that back. I guess we could award damages to try to satisfy that, but I think it's probably easier for everybody, excuse me, if I simply lay out a plan that will give them access so that that becomes removed as an element of damages. I think the last two sections of the fence need to be removed. It looks like that can be easily done. It doesn't look like they're permanently anchored. I don't know for sure. I suppose possibly the cedar posts, but that's a relatively minor thing. Take the last two sections out. I don't think any trees need to be removed. I think smoothing out with rocks sufficiently wide for a dump truck to be able to get in. And I think the width of a dump truck is probably whatever the maximum width of a vehicle is, which is probably about 8 feet. So I would say no less than 10 feet, which would be sufficient for a heavy vehicle to get in there. And put the big rocks in, fill the ditch with the big rocks, smooth it out so an ATV or a truck can get over it. This is a temporary measure. The other thing I'm going to do is very strongly encourage that there be some conversation about working out a permanent resolution. You don't want the drain commissioner establishing a drainage district out here. Nobody wants that. It looks to me like the measures that were taken to control erosion could very well be effective. But I guarantee you, if you fill in that ditch without making arrangement, you're going to have a significant erosion problem the next time there's a major rain. And I don't think that helps anybody. Who knows where the water will go? It will find its own course, and it will dig a ditch. Whereas if you put the large rocks in and can do it and smooth it out sufficiently so it can be driven over, that will allow water to pass through and hopefully at least temporarily control the drainage. I mean, ultimately what you might be talking about is a culvert so that it can be, smooth. Nobody's asked this, but clearly there should not be any vehicles parked on the roadway portion by either party. Once you get onto the plaintiff's property, it doesn't make that much difference, but there shouldn't be vehicles parked on this easement to block access to anybody. I mean, ultimately, the easement, as described, if I remember correctly, benefits more than just the parties to this lawsuit. So, but that's for another day. So I hope there's enough clarity here. I'm not going to grant any kind of relief as to harassment, nothing of the sort, at least today. What I'm doing is what I believe is the minimum necessary to allow the Tappings to get in and out over the easement, to haul sand in if that's what they want to do, or simply access it with a ATV. And again, I would strongly encourage some conversation so that we're not duplicating work. For example, if a culvert would solve the problem, would it be easier to put the culvert in now rather than have to excavate the rock, put the culvert in, and then refill it with just some conversation would be good, because you guys can fashion a better relief than I can. And the other thing is, I realize there's a lot of emotion going on here. There's a lot of resentment. The best thing that can happen is that hopefully, once we figure out what makes the most sense here, that there can be some um, peacemaking take place. The last thing you want to do, particularly at a lake, is to be at odds with your neighbor. I mean, every time you go down to the dock and look across and see them and they're frowning back at you, I mean, it's just, it's not good for anybody. So I realize that might take time, but I hope it can take place. That would be my goal. Council, is there sufficient clarity in what I've said so that we can do a temporary order until I can grant permanent relief?
There is just, I would only ask if the court is going to put like some sort of time on when that's, that 10 feet worth of, and you're talking about a section of fence that's closest to the lake, 10 feet at least of fence closest to the lake.
There are two sections of fence at the very end at the lakeside. If those two sections are removed, which would be 2 posts and 4 rails, if I remember correctly, and if ultimately I deny the relief, it would be a pretty easy thing to be able to replace them. They're not, there's nothing particularly permanent about those railings, so it's a pretty simple thing just to move them. That's probably wider than it's needed, but I'm not convinced that just a single section would be quite wide enough. So I want to make sure that you don't have to come back in here and argue about that.
Right.
If I remember correctly, Mr. Lindsay, in the response, you had indicated that this could be done in a matter of a few hours.
Yeah, Your Honor, I don't want to commit my client, but I mean, if we could have, over the weekend to do it, I think that would be sufficient. I think it's supposed to rain tomorrow, but yeah, I think it's a couple hours worth of work at the most.
And then
Okay.
that'd be great. That'd be great. The only other question I said is that also include the smoothing of the ditch, or will that take any additional time? Or
Well, the fence could be moved in minutes.
right?
I mean, it's again, I don't know how the posts are anchored, but my guess is they're probably just buried in the dirt. I wouldn't have anchored them, but the smoothing of the rocks is the only thing that would take a little longer. I like Mr. Lindsay said, I think that's perfectly reasonable to give them that time, and that should be sufficient.
Oh, I agree. Just curious.
My only suggestion was that if ultimately the best fix for that erosion problem is a culvert, maybe you should talk to your clients and see whether or not that's something that could be done rather than having to re-excavate later. I only throw that out as a suggestion. I'm not ordering anything in that regard.
All right. Yeah, that seems sufficiently, something I can reduce to an order and run by Mr. Lindsay. And
I guess, Your Honor,
Okay.
the fence posts are no problem to remove, and I'm wondering about. I don't want to be in a situation where I promise to fill in the rocks, but then we decide to put the culvert in as an option. So as long as Mr. Bankston will work with me on that particular issue. He did provide me with a proposal this morning that I would like to review with my clients and may address a couple of these issues regarding drainage.
sure.
Okay.
I would only say that the court's not ordering anything with respect to the culvert, right? So
No,
we're just
it's merely a suggestion
Got
that
it.
might save some time. I think there's mutual interest here in controlling erosion. So some cooperative resolution to that is probably a good idea.
The only reason I asked Judge is obviously a culvert. It's probably not something that can be done short term. I could be completely wrong about that, but from a preliminary injunctive relief point of view, I certainly we're open to options. I just think smoothing the ditch has to first occur, and then a discussion perhaps about whether a culvert makes sense or not. Happy to have that discussion.
Again, what I'm ordering is a smoothing of the rocks. What I'm
Okay.
suggesting is
Got it.
if rather than Monday, you can't get a culvert in that fast, but by Tuesday you could get a culvert in that would provide a more permanent solution. You should at least talk about that. It just makes sense.
We will
Yep.
do it. We will talk.
Okay,
Sounds good. Thank you, Your Honor.
you're welcome. Have a
Thank you,
good day,
Judge.
everyone. Okay, looks like everyone's here.
Can you let me back in, please? I
Sure.
got out.
Okay, well,
I'm going to.
okay, thanks. Bye. Morning, Your Honor.
Good morning.
Good morning, Your Honor. I was just talking to Mr. McCord, so I think he's coming online.
He's been here. He popped in just as I was starting the other hearing. But since I'd already started that one, let's see, Mr. Murray's not on this trust and estate matter, the Kelly trust and estate. The problem with when I'm letting people in the waiting room, by the time I click on a name, sometimes another one jumps up there. So, Mr. Murray, if you could just mute your computer. Your case is next up.
Okay, thank you.
Mr. excuse me, Anthony Kelly was in the waiting room earlier. I don't know what happened. Maybe he had to go somewhere, but he's disappeared.
Okay, Judge, he did indicate this morning when I talked to him that he was having all sorts of computer and internet issues, so I suspect it's related to that. And he indicated that if he was in there, great. If not, move on. So.
Okay, fair enough. I mean, I do have the ability to call him if you'd like me to do that.
No, I think it's okay. I think he was pretty intent on getting the internet issues resolved this morning, so.
Okay, this is a matter of Norma J. Kelly estate and revocable trust. When we were last here, I invited the filing of a summary of what needs to be done in order to resolve this. I got that from Mr. Rick. Mr. McCord, looks like you did not file anything. Looks like, are we ready to proceed for me to order final relief?
I think so, Your Honor. I did talk to Mr. Kelly this morning, Anthony Kelly, regarding, and throughout the last several weeks about the options of, requesting an evidentiary hearing and doing those things. But I know the court and Mr. Rick, Mr. Rapley, and all the parties had an extensive evidentiary hearing already. I'm not sure having another one is going to do any good other than spend everybody's money. I have the transcripts from that. I think Mr. Rick and I tried to resolve things up until just a couple minutes ago. I'm not confident that's going to happen. I always hate to turn away from trying to resolve things, but I think this case is pretty old. It's, pushing 4 years old at this point. I'm not sure any more conversations or mediations is really going to change much. I talked to Mr. Kelly about all of this, and he was of the opinion that he would just like some final relief. I do anticipate some appeals from Mr. Kelly. I won't be involved in those, but I do think that's the plan from Mr. Kelly's end. I guess that's about all I have to contribute.
All right, well, looking at what Mr. Rick has submitted, with the exception of the matter of attorney fees, I think his proposed accounting accurately allocates based on the findings that I both made and indicated that I would likely make based on the evidence that had already been submitted. I think his proposed accounting is accurate. And the only issue is the attorney fee issue. And if you're conceding, Mr. McCord, that his attorney fees are reasonable in amount, I mean, those I know I can't, if I can't rule on attorney fees without making specific evidentiary findings. I think the case law is pretty clear on that. But if there's no objection to the reasonableness of the fees, they appear to be reasonable to me. But that's the best I can say about that.
Yeah, Judge, and I would agree. Like I said from the beginning, based on the bills that I've seen, I think the attorney fees are fair and reasonable. Nothing jumped out at me as inappropriate. I think it's you know, Mr. Rick's attorney fees are high, of course, but this has been a case that's went on for 4 years and there's been a lot of work involved. So I don't have any objection to the attorney fees. I've discussed that with my client, and that's where we're at.
And I think there's no question that the estate and the trust were benefited as a result of the fees that Mr. Rick expended. So I'm prepared, excuse me, to enter either an order or a judgment consistent with Mr. Rick's proposed restated accounting.
Very good.
Your Honor, just as an officer of the court, I feel like I need to point out that the accounting I submitted does not include Mr. McCord's attorney's fees. And so if we factor those in, you know, those have been paid out of estate assets, apparently.
They have.
So there may need to be some minor modification on that particular issue, but otherwise I think it's accurate.
I agree, the accounting needs to reflect Mr. McCord's fees. If you can work that out, great. You can just include that by stipulation. If not, just bring it back in front of me.
Very good. And I guess, Judge, just for the record, last time we were in court, you ordered that that Mr. Kelly turn over the funds to a third party. Mr. Rick and I have agreed on American Title. Mr. Rick's prepared an escrow agreement. I caught up finally with Mr. Kelly this morning again, and he's supposed to bring in a check for all of the funds out of the TD Ameritrade account made payable to American Title. So I'll plan to get that over to them today, and copies to Steve and all that stuff. So
very good.
So, Your Honor,
anything else I need to address today?
Would you like me to prepare a proposed final order or a judgment, or what would you like?
Exactly.
Okay. All right, I will get that over to you as soon as I can.
Okay, thank you, gentlemen. Sorry to keep you waiting.
Thank you, Your Honor.
Parma Township versus Chase.
Morning, Your Honor.
Good morning. I see Mr. Berlinski is on this file. Have you spoke with him?
I'm from Mr. Berlinski's office. I'm covering for him, Your Honor. I'm Jeff
Oh,
Landis.
I'm sorry.
That's fine.
So let's see. Now I'm trying to figure out why Mr. Jeff Murray is here.
I don't think he's part of our case.
Let me find out. I don't want to keep him hanging.
I'm not, Your Honor. I'm here on the Davy Foster matter. We have a motion to show cause.
Oh, okay. Fair enough. We'll call you next.
Okay, thank you.
Okay, Parma Township versus Chase. Mr. White, this was, I guess, a request for a preliminary injunction that was combined with the complaint?
Yes, Your Honor. You should have received an answer to the complaint, I think, from Mr. Berlinski, as well as an answer to the motion Did you receive those?
Yes, I did, and I've read both of them.
Thank you. Unfortunately, I didn't get a lot of direction from the answer to the complaint, because as you can tell, it's simply it's a continual, we don't have any information or knowledge to answer. This is one of the more unique cases I've seen in all the years I've done municipal work. Essentially what the defendant has done is he has erected and rented out 2 structures without the benefit of a single inspection of any kind. The structure that's on the defendant's home property, so to speak, was applied for to be an agricultural building, and through some interesting twists of facts and circumstances, the township found out that he had actually made that into a rental property. Again, we have no idea what any of the inspections were, because as an agricultural building under the Michigan Right to Farm Act, none of those are subject to permits or inspections. They're just simply agricultural buildings and they're exempt. To make matters worse, the defendant owns a property adjacent to his that is not buildable due to some road frontage issues. Again, the defendant built a home without a single permit and rents it out. As you can see from what we attached to the complaint, he rents it out for $1,500 a month. We have no idea how he got an address, how he gets electricity, how he gets water. I can tell you that the answer to our motion says he has an address with the Postal Service. And while that may be true, Jackson County, GIS, they have no idea. If that person in that adjacent property picked up the phone and said, my wife's having a heart attack, I need help, Jackson County GIS and the Jackson County Dispatch would say, we have no idea who you are. They are absolutely clueless. He completely went off the grid and built a home. We have no idea the safety. I understand that this is an unusual set of circumstances, Your Honor, but the township can't allow these 2 completely uninspected homes to be occupied by people. The risk is incredible. It puts the township at risk. It puts the people that live there at risk. We don't have the slightest idea if any of this is suitable for habitation in any way, shape, or form. We have to protect our residents, Your Honor. These 2 homes need to be vacated. If the court would like to set an evidentiary hearing, I know that Mr. Berlinski suggested that in his answer, and I would welcome that. I think the court needs to really hear, especially given an answer that really answers nothing. The court needs to hear, I think, from the defendant and the township exactly what's going on here and the incredible risk that exists.
Mr. Landon?
Yes, Your Honor. And so, this isn't my file. I'm covering this, but I've read the entire file. So I've read the complaint. I've read the answer. You've indicated you read Mr. Berlinski's response to this motion. I could sit here and restate what Mr. Berlinski said in that motion of why this should be denied and why it should be set for an evidentiary hearing. But if Your Honor's indicated to me that he's read that response, I won't take up your time to do that. And is that the indication that you did read it, Your Honor?
I did read it. My inclination here is not to grant a preliminary injunction, however, without an evidentiary hearing, but to order an evidentiary hearing and advance the trial on the merits and get it all resolved at once. If what Mr. White is saying is true, this dwelling is being illegally occupied, if that's what I find to be the case, my ruling is going to be they got to vacate it. So your clients either need to work diligently with the township to rectify all of the shortcomings here, if they can be rectified. I don't know if that's possible. I know Parma Township tends to be pretty reasonable in accommodating things, but I don't even know if it's possible, given that there were never any inspections. I mean, who knows that the wiring is adequate, that the plumbing is adequate? Is there a septic tank? I mean, there's nothing from what Mr. White is telling me, from which the township could even make a reasonable determination that the dwelling is safe and can be retroactively permitted. But if there's a way to resolve it, your client should be discussing that. If not, we're going to find a date relatively quickly. Mr. White, are you going to want the opportunity prior to a hearing to get access to these buildings for discovery inspection purposes?
Well, I'm not really too concerned about inspecting them. What I am concerned about is getting the information as to these tenants. I don't know if maybe they're entitled to notice and an opportunity to be heard in this case. I mean, these are people that clearly have rental agreements that are impacted by this litigation. I was going to check with the court. I'd like to get the information as to who these people are and their contact information, but perhaps they should be named. They should be named as parties. They certainly have an interest here.
And again, I kind of lost sight of the fact that these were occupied by tenants. You're absolutely right. They've got some possessory interest in this property. I think they're necessary parties, and they will need to be joined. Mr. Landon, you need to make sure you get that information to Mr. White as quickly as possible. Like I said, I'm going to advance this, but I don't want to tie anybody's hands with respect to crucial discovery, but I plan to move this along rapidly.
My problem is, Your Honor, you saw the answer. The answer, I have to file a motion essentially to strike it or for more definite statement. I have some very specific allegations, and they basically say we neither admit nor deny and leave the plaintiff to their proofs. That's most of these allegations. That type of response is simply insufficient. It's hard for me to go forward with discovery and things like that when I get an answer that basically it didn't answer anything. It makes it difficult for me to move forward. But I can include a motion a motion on that in short order.
I think you need to do that. I would agree. When a party has knowledge of the facts, they need to respond appropriately. To deny knowledge when you clearly must have knowledge is frankly a violation of the court rules. If you, I mean, for example, let me just pick one at random.
And Your Honor, I'm remaining silent, but I would have to review everything as you review it because it's not my work product.
Sure. Hold on just a minute.
Not that I don't want to defend Mr. Berlinski.
Sure, Jeff. Sure.
Yeah, for instance, the first one that pops up in count 1, paragraph 6, on or about March 8, 2006, defendant applied for and received a building permit for a 50 by 100 foot one-story pole barn on the property commonly known as 11665 Mackey Road. At the time of the application, no other structures existed on the property. The defendant absolutely knows whether or not that's true. To file an answer that says the same is neither admitted nor denied for the reason the defendant lacks knowledge sufficient to form a belief as to the truth. That doesn't fly, counsel. They have to know. They must know. This is knowledge that is within within their minds. They got to know that it's either true or it's false. They can't say that they don't know. They got to know. So I'm not going to make Mr. White file a motion. I'm going to order today that an amended answer needs to be filed and responses consistent with the actual knowledge of the party of Mr. Chase has to be provided, or I will definitely award sanctions.
Thank you, Your Honor. I'll get with Mr. Berlinski or Mr. Landon on that. Should we check with your staff as far as a date and time for the evidentiary hearing, or will Dawn get with us? Or
well, let me, it would be Patty, but what,
that's right.
Realistically, do you have a sense that the very earliest you could be prepared to move forward, Mr. White?
2 to 3 weeks.
All right. I probably won't be quite that soon, but that guides, that provides some guidance. I will have Patty find you a date and time, and she'll get with you to make sure it's clear on both of your calendars.
Very good. I'll prepare an order consistent with your rulings today, and I'll get that over to Mr. Landon and Mr. Berlinski.
Thank you.
Thank you, Your Honor.
Thanks, Jeff.
Thank you.
This one. Okay, let's see. Okay, looks like we're ready for Foster versus Moss.
Good morning, Your Honor.
Good morning.
Jeffrey Murray on behalf of Defendant Liberty Mutual.
And this is a motion to hold a non-party in contempt for failing to produce records?
Yeah, so to set a hearing to show cause. We had subpoenaed one of plaintiff's insurers, AAA or Members Select, in September. We've tried to reach out to them in the interim to get responses to that subpoena. We've had no luck. And so today we brought a motion to show cause.
All right, I'll grant your motion. You can find a date that works for your schedule. Obviously, the third party needs to be served sufficiently in advance of the hearing date so that they have an opportunity to appear and defend themselves.
All right, I appreciate it, Your Honor. We'll submit an order.
Okay, thank you. Have a good day, Mr. Murray.
Thank you, you too.